My name is Volker Kruger. Elmari Richter has joined us from Velden-Duffey. I read an article in the City Press, lesbian granted parental rights in insemination case. Surely that can't be. Elmari, please explain what happened there.
Yeah, well, the constitutionality of a certain section in the Children's Act was challenged before the High Court of Pretoria in the matter that are referred to in the article. Now, the section that was actually challenged deals with children born from artificial fertilization. Now, the general rule, and I'm sure all of our listeners are also aware of it, is that persons donating sperms or gamete or surrogacy parents, they do not have any parental rights and responsibilities in respect of a child born from the donation. Instead, the two spouses who consent to this artificial fertilization, they will be the parents of the child born from the donation. So
I think there would typically actually also be an agreement signed between the parties, not to confirm that there are no parental rights
definitely
attached to the donors. No?
And usually one of the spouses will be the biological parent. So, for example, the wife would be inseminated and she would be pregnant. Or the dad will donate the sperm to a surrogacy mom. But then, no matter the donor or the surrogacy parent, the two parents who consented to this fertilization, they will be the parents of the child. But now what's very important to note is that the Act does not include life partners. The Act very specifically refers to spouses who consent to this fertilization, which actually now means that if you are not married and you consent to this artificial fertilization, that only the one partner in this relationship will actually be acknowledged as a parent. So, for example, if the sperm gets donated to a person in the relationship, the person fell pregnant, she's carrying the baby. She will automatically be the mom. But now she's unmarried, but she is in a committed relationship with another person. That person who's in the relationship and who will be part of the child's life, who actually has the intention to be the mom of the dad, will not be acknowledged as a parent.
Yes.
So, for example, if the child's at school, if the child's born from artificial fertilization, but the parties are unmarried, now later on the child's at school, the child gets hurt, now the schools are only obliged to call the biological parent. Because the other parent who plays an active part in the child's life is not acknowledged as a parent of this child. So this specific matter that you mentioned previously, and it was also the matter where the constitutionality of this section was challenged, it is a lesbian couple who are in a very committed relationship for quite some time. They have their own reasons why they don't want to get married, but they have this desire to be parents, and they decided to follow the route of artificial fertilization. I mean, obviously, we all know two women cannot have a baby together. They need sperm for a baby to be conceived. So they started the process, but they quickly realized that, listen, only the parent or the person in the relationship carrying the baby will be seen and acknowledged as the parent. The other partner to this life relationship will not be seen as a parent. And that's why they then rushed to court and asked the court to declare this section unconstitutional. Obviously, it infringes the child's right born from the artificial fertilization, because actually that child, the right of that child to a family and parental care is violated. And then furthermore, also the two partners in this relationship, their rights to equality and dignity are also violated.
Which are all constitutional rights, no? Those rights
all
are
constitutional rights. Yes. So the court considered all the submissions. There were also a few experts who also gave their submissions and their opinions on this matter, and then the court declared this section to be unconstitutional, and then also made an order that it should be amended. So the section will be amended by merely adding life partners to this section as well, to make provision for spouses and life partners who consent to this artificial fertilization to be both recognized as the parents of the child.
Yeah, interesting. And I guess another example of how our law is developing over the years, and specifically as of late, there have been a couple of cases, I think, where the rights of life partners have been recognized, and where life partners have basically been put in the same position as married spouses.
Yes.
So
Yes.
our law has really changed in that respect. What springs to mind is interstate law of succession, where there were also some court cases where the courts held that the life partners are entitled to inherit as surviving spouses. If, for example, the one person passed away without leaving a will. Also, in terms of estate duty, which is the tax payable upon death, it's now clear that the life partner, or whatever the life partner inherits, is also exempt from estate duty, just like the exemption enjoyed by a married surviving a spouse that inherits, etc. So, yeah, I think if you look at all those developments, this one makes sense as well.
Yeah, definitely. And I just want to mention, now that you said the interstate succession, that was actually an example that was used and addressed in this court, the court case, because they said that if the partner who's not basically recognized as the parent now passes away, the interstate, the child born from the artificial fertilization will not have a right to inherit, for example, because the person will not be recognized or known as the parent. So there's lots of consequences, and I really, I'm all in favor of these changes being made. I think it's time for a change. Getting married is not necessarily something that all people and parties intend to do. Some people are very happy in a life partnership, and they should also have equal rights than married couples.
Yeah. Obviously, you don't just automatically qualify as a life partner if you live together for a week or two. So there have to be requirements met, which we can maybe deal with in another program. So it's not that simple just to qualify as a life partner. Those decisions that we referred to make that clear. So there would be a case-by-case analysis of whether you qualify as a life partner. But in general, I think it's clear that in terms of our law and the latest developments, life partners now do enjoy the same rights as married couples.
Yes, I agree.
All right. Thank you.
Thank you.